Could you hand me that pile of stuff, please? Thank you. Thank you. Here, let me give you maybe those.
Chris, are you going to share any deals
The deal form? So what the deal form is for paid members. If you have a deal that you are interested in presenting to the rest of the group, you have that opportunity to do it at the investment club. And how many paid members do we have that may have a deal to share? Okay, so we will do the deal form at the end. That's
Okay.
Is that okay? You guys do the deal form at the end. That way, if you have any questions, they can present you, and then text the guys. So don't leave, because there's some. How many of you guys have done a wholesale deal? Have bought a property from a wholesaler here? Almost all of the deals I have. Made a ton of money from deals that people have brought to the club. So, yeah, we'll do that at the end. So,
Hi, everybody. I'm Stan Brazington, and Rob Rowley here. And I recently, over the last 6 months, I've noticed that the real estate community is not familiar with all the changes that the Department of Financial Institutions have implemented since Hope and Change came about. And at a federal level, the SAFE Act was passed, and the SAFE Act was enacted to primarily how it affects the real estate community is that it licenses loan originators. And in their wisdom, they put language in there where you could construe a seller offering financing on their real estate as a loan originator. So loan originators have to be licensed at the federal level through the National Licensing Registry. And then the Dodd-Frank Act was enacted, which made all sorts of other changes to the mortgage industry. As a result of the SAFE Act and the Dodd-Frank Act, the states had to implement changes in their consumer lending laws and in their mortgage broker laws, and the state did that. And in 2009, in the summer of 2009, the state of Washington radically changed the Consumer Loan Act, and it became very complicated to offer seller financing. Has anybody since 2009, summer of 2009, closed a seller finance transaction without getting the Department of Financial Institutions director's permission? My dad raised his hand. He got permission on this last one. And the I think you're okay. Well, yeah, okay. Well, we'll see whether you're okay or not as the meeting progresses. So anyway, in this 2009, and it's been a moving target. Holy moly, they changed the rules. Initially they had language in there where you could close a diminuous number of transactions as a lender, and you didn't have to get licensing. Diminuous meaning a few or something. What's diminuous mean?
De minimis.
De minimis.
Minimal.
Minimal, right. And less than 5 is what I understood. So then then what was really scary is in 2013, they took that language out. They took all the language out. There were other than a business transaction, there was no way for a seller to get seller financing, offer seller financing on a transaction that was consumer in nature without going to the Department of Financial Institutions and getting a written waiver. And nobody was doing it. Nobody knew about it. So I started talking to people like Bob Delaney, didn't know about it. This summer I emailed Bob that Demco letter. And that's why we're talking today, is I want everybody to know about the seller financing considerations. And as investors, you might want to know this so that if you're talking to a seller and you're looking to buy a house and the seller is willing to finance it for you, you know the rules. And as investors, the first rule is if it's a business transaction that's not going to be owner occupied, there's no licensing requirements. It's exempt. If you're a flipper and you plan to move into the house, that is prohibited. The seller can't provide you with financing without getting their permission, because that's considered a residential mortgage loan, and they closed that gap in their infinite wisdom this past summer. So anyway, there was a video that I was going to show that kind of outlines it all, and I just didn't know whether I could round up a projector, so I'm going to pretend I'm Annie Fitzsimmons with the Washington Realtor Group. And this is a synopsis, almost word for word. I'm not much of a typist, but there was a pause button, and all I had to do was she had on her screen these bullet statements, and I just typed them word for word. So I want to go over that, and I'd like Rob to interrupt me if I go astray or if he has something important to add.
You never want a lawyer to
You know, the first thing I want you to keep in mind is that you have to pass the state test, and then you have to pass the federal test. And there's different considerations at both the state level and the federal level. So let's talk about the state concerns first. This law was passed in 2009. As a result, many sellers have unintentionally violated the Consumer Loan Act. That's been a problem for DFI, so they started having some hearings this past fall. And in September, this Washington Realtor Association posted on YouTube this video that we're talking about right now, and it was an attorney, Annie Fitzsimmons, and she shared that the first rule that you got to look at is if the seller is offering financing on the residence the seller owner occupies as their primary residence at the time of sale, the Department of Financial Institutions will not have a problem with that seller financing. There's actually an exemption from the Consumer Loan Act, a specific exemption that allows that. So it would be my opinion, and I want to ask Rob, that you probably don't, in that situation, you don't have to get written permission. There's already an exemption in the Consumer Loan Act for that transaction. The second thing is if the property is raw land with no immediate intention to build a home, the Department of Financial Institutions will not have a problem with that. Well, what do they mean by immediate intention?
next year, the year after?
Well, I actually spent yesterday doing research, and they changed the Truth in Lending Act. There used to be definitions in the Truth in Lending Act, I swear, and I couldn't find that definition. So I looked in RESPA, and in RESPA it says that if you plan to build within 2 years, you have an intention of building, and that it's a resident. If you plan to build within 2 years and it's going to be a owner-occupied residence, that's a residential mortgage transaction for you to buy that property. So my opinion would be, as the state of Washington probably is looking at a 2-year window. Would you agree?
Yep.
Okay. If the buyer is buying an investment property or is buying a second home, DFL will not require a waiver for this type of transaction. You know what? I couldn't find that language anywhere in the Consumer Loan Act. This attorney on the video said that you didn't have to worry about that, but when you look at the Consumer Loan Act, it doesn't say that. Maybe Cindy Fazio, the staff attorney, told her that. So what I'd recommend is, if there is a specific exemption for business loans. So if you got a business loan, it's not going to be owner occupied, there's a specific exemption for that. But if it's a seller financing deal on a second home, I would get the Department of Financial Institutions written waiver of the rules. Okay, then, however, if the seller is selling property that is not owner occupied by the seller and will be owner occupied by the buyer, this triggers a requirement for a DFI review. I think that didn't say that in the Consumer Loan Act. I think this is coming. I think this stuff I'm sharing with you that Annie shared is stuff that DFI hasn't even published yet. This is what they're going to publish. This is how the rules are going to change just in the next few months, that's going to trigger it. In the meanwhile, if you have anything other than a business loan or a owner-occupied residence, get a waiver. It's real simple to get a waiver. You just call Cindy Fazio. You might email her something if she wants it, and she replies with a waiver. Is that the experience you had, Dad, or did Terry handle it? Yeah.
But she said it was pretty simple.
Yeah. Go ahead.
You know if this is the same for Idaho?
There's no requirement. This is Washington law, so this would only be for Washington transactions. Federal obviously would be encompassing all things.
Yeah. And in Idaho, I'd sure watch because it could change any minute now. But you're still going to have those federal concerns, and we'll get to those very shortly. So you'll see I had some comments down there. It occurs the only clear exemption from licensing is the business purpose exemption and the exemption for any individual who offers and negotiates terms of a residential mortgage loan secured by the dwelling that served as the individual's residence. Those are clear exemptions. From my point of view, anything else, call Cindy Fazio, get yourself a waiver. Annie also failed to mention that the state of Washington, and I couldn't see this in the WAC, or the RCW, but the state of Washington will not allow the seller to sell the note. You have to hold the note to maturity.
Serious?
Yep. On a consumer transaction. If it's a business transaction, the Consumer Loan Act doesn't apply. But when they, huh?
Unless you,
Well, if you get a waiver, then great. Then great. But they're wanting the exemption I received, and the feedback I received on a property that we were seller financing. We ended up doing a lease option, but Cindy was adamant that the sellers couldn't sell the note. So let's go on to federal. Does anybody have any questions about state law? Yes.
Actually, I had a quick question about the selling the note. Like, what if you have it written in a note that it can be assigned?
Well, if the state of Washington says that you can't assign the note,
Well, so there was that language in there too.
yeah. Well, this is the state of Washington telling you can't sell the note, and you can't sell the note.
so if you're assigning it without compensation, I suppose you're not selling it. If you're just assigning it to somebody else, and you're not.
Well, it said you couldn't sell the note. You could probably pledge it as security for a loan.
That's an attorney question.
Yeah.
Huh?
Yeah.
Yeah.
That's a rough.
Yeah. What do you think, Rob?
Depends on who's paying me, I guess.
Yeah. Yes.
So what's the question?
So they asked just assigning it as opposed to selling it. Can you just assign the note and without compensation? I'm assuming, let's say you just went out of this. I'm going to assign it to Stan because I can't handle these guys. But Stan, you just take over this.
And you pay and there's no compensation, and nobody's paying tax, or nobody's deducting anything on their tax returns. Then arguably that's not there's no consideration, so it's not a sale. It's
I think-
a gift at that point.
What do you think of Stan Brazington assigning it to his IRA, or Stan Brazington assigning it to Stan Brazington's corporation?
Well, so
I think
long as
that-
that's still Stan Brazington,
Yeah.
there's no issue. Just like when you assign a property, for example, if you had a piece of real estate that you owned as husband and wife and you transferred into your LLC that you own equally with husband and wife, there's no excise on that, obviously, because that's not under both state and federal, that's not considered to be a transfer. Same thing as if it's still you and it's your company and
Right.
your retirement plan. As
Yeah.
long as there's no gain from the IRS viewpoint, I can't see that would be a sale.
I think these rules are going to continue to change. So watch. It's going to be a moving target, because I'll get to your question in just a second. I want to make this point real quick before I forget. I have attention deficit disorder. But this is going to create lots of problems. There's going to be sellers out there that die. There's going to be creditors that say, pay me, right? And the state said that the seller can't sell the note. That means the estate can't sell the note either, right?
Yeah.
I mean, it's going to cause problems. And as and the state isn't smart enough to see the problems on the horizon. And but as those as the problems arise, and as there's an uproar, and you know, there's going to be changes made. Did you have a question?
Well, you probably, couldn't you put claim it to a trust and then check out the seller beneficiary interest of the trust? They're not selling a note.
I wouldn't touch that with a 10-foot pole.
And again, that's really a form over a substance argument. I mean, you can try to play that, you can try to win that argument with them, but they're just gonna say, well, look, you know, we know what's really going on here. You know, it's still the same beneficial owner.
You change the beneficiary.
Right, but see, that's the point. I mean, those type of transactions are almost always gonna be disregarded.
Except for the name of the note would only change when it's put claim into the trust, which
Right.
is you've done that, you know, for many years ahead of time.
Yeah, but at the end of the day, somebody has to be able to know what you've done. I mean, if nobody ever finds out, then great,
Yeah.
fine. This is just a scenario we're talking about is, you know, what you want to do is if you want to practice best practices, that's all.
Yeah.
How is this gonna affect current seller contracts that are out?
Well, those would be vested. I mean, you can't undo a contract that's already in place.
So going forward, is a lease option a way to sort of work around this?
That's one technique for doing that, because that's not considered to be a sale. Both under, you know, as you know, for IRS tax purposes, for example, a lease option is not considered to be a sale. It's not
Well-
considered a sale for gain purposes until you actually close the deal.
Now keep in mind that so far, this is only going to be, you just have to get the state's permission to offer the seller financing, and they're going to give it to you. But if they start seeing your name time and time and time again, they might have a problem with it.
So
Well,
it's
you
per,
see-
per transaction that you have to get the
It's per transaction, right?
per waiver?
Per transaction, yeah.
So you can't do something like SEC and just have
Blanket.
a blanket.
No. And we'll get to the federal concerns just real shortly.
Well, why this would become a concern for anybody is, okay, well, I mean, as you know, if you drive on the freeway, you know, any cop will tell you if you drive more than 3 minutes, you probably violated some rule or regulation. You know, the same way it goes in real estate. If you are out there investing anyway, most likely you've violated some rule or regulation down the line. So, where this would become a concern that I would see is if you do the seller financing and then the day comes when the person defaults and you decide, well, I'm going to go out and you call me, because I do a lot of foreclosure work, both in Washington and Idaho, for everywhere from Northwest Trustee down. And where it becomes an issue is that if I try to foreclose on that note and the borrower is saying, well, you didn't jump through the hoops, you didn't do all of these things, and they would raise that as a defense to
Yeah.
the foreclosure. And so what it does is essentially gum up the foreclosure, and you thought that you had this perfect contract that was you had all that equity in the transaction, and you were just going to do a simple, you know, a contract forfeiture or a foreclosure, and you get the property back with all that equity. And next thing you know, you're tied up in litigation for the next 2 to 3 years.
Now,
And it's a pretty clear violation. Either you did or you didn't get the clearance. So that's the point of doing this. So when you do the seller financing, if it's just a small $10,000 to $20,000 or $30,000, $40,000 transaction, you're probably okay. If you're selling a $2 million piece of real estate on a contract, you'd probably be worth going through to get the waiver.
I would get the waiver in every instance. And here's why. Is a violation of the Consumer Loan Act a consumer protection violation? And what does a consumer protection violation carry with it in?
Get you trouble damages.
Trouble damages.
You get to get the Attorney General's office, theoretically.
Okay. The last time Gene and I were involved in litigation where a jury awarded a judgment of $14,000 on a deal that Gene and I put together. And that judgment, I think it was, what, 1989 or so, or something like that. Long time ago. Triple damages, 45 grand, that's no big deal. We wrote a check. We had wrote checks to defend ourselves for $40,000 or $50,000. That's okay, cash flow was good. The attorney didn't like what we were doing, so he awarded $140,000 in attorney's fees to the pro bono attorney that represented the borrower. So we wrote a check for $140,000. Then in our infinite wisdom, we decided to appeal it. So we had to post a $50,000 cash bond to the court to cover their attorney's fees on the appeal. We lost the appeal. That 50 grand's gone. And the money that and the attorney that was representing us, he didn't do the appeal for free. And I can't remember what those checks were. So you add all that up, that's $300,000 or $400,000 on a lousy $15,000 judgment. Ask me if I want to ever do that in my lifetime again.
I feel better about my 65.
Now we had a simple solution to our cash flow problem. Dad and I cut our salaries in half for 5 years. And our salaries, that was in '89. We sold in 2004, and my salary never got back to what it was in 1992. Never got back there. It cost me hundreds and hundreds of thousands of dollars for a lousy $15,000 judgment. It wasn't a multi-million-dollar home. It was a true story.
I don't think you remember this, but you remember I sued you once.
Oh, I remember that. I was sure. I remember. Oh yeah, Rob and I go way back, but we won. And I want him to know that he represented his client well.
I had the camp family.
And we ended up buying.
He stole a piece of property.
Well, we ended up paying his client $72,000 for a landlocked piece of ground overlooking Liberty Lake, a quarter mile from the nearest paved road with no ingress or egress. I was there this afternoon at 5 o'clock showing it to a buyer, and Dad doesn't know that. Nice couple from Phoenix, MD, and it's a beautiful property. We own the 10 acres with road frontage, and they own the 10 acres without road frontage. Together it was 20. The 20 was legal. Both of the 10s were an illegal segregation of the 20. So his client got $72,000 of our money in 2006 and probably put it in the stock market, and it's now 150 grand. And Dad and I have been paying $3,000 a year in taxes since then.
You whine all the time. Go catch your wages.
Yeah, okay.
We sold it once though for $300,000 on a contract. We got it back again.
Yeah, that's what I'm saying. And you didn't get your waiver.
No, but it didn't require a waiver. Well,
why don't you give me a customer list? Let me contact them.
Yeah. I'm not sure what the rules were in August of 2011. We didn't get a waiver.
But you weren't planning on building on it, right?
No. Well, no. The buyers were planning on building on it. 3 years from then. You know.
Oh, our plans changed.
Yeah. And they're very good friends. They did have a change of heart. They only put 10% down. They decided they didn't want to live overlooking Liberty Lake. They wanted to move to the Okanagan on a real ranch. And they just asked us if they could give it back to us. And they did. They made us a free sign, a free for sale sign.
They took the prompt payment for 2 years.
Yeah, it was great. Well, let's move on to federal law. Each and every one of these federal considerations have to be met, okay? Number one, the seller must be a natural person, estate, trust, and not a loan originator. So if you're a licensed loan originator, you cannot offer seller financing. Corporations, LLC, and business entities cannot provide seller financing. Keep in mind, business transactions are exempt. So you could sell your property to Rob and seller finance it to Rob as a rental, but you couldn't seller finance it to me if I plan to move in there and make it my home. Yes?
So I purchase all my properties in a trust,
Right?
so that makes number one good go for me because
Right.
it says trust. But if I bought it in an LLC, I couldn't.
You couldn't seller finance it.
Even if it's to another business entity?
If it's a business loan, yeah. If it's a business transaction,
Yeah, it's not.
those are exempt.
So did you say if you're a licensed loan officer, you can't offer seller financing?
Correct.
Thank goodness it's, you ever take that test.
I let my loan originator's license lapse year end. Wasn't worth it anymore. Go ahead.
Just a quick question, so overarchingly, this has to deal with just real property, right?
Pardon?
I said overarchingly, as far as like this seller financing is concerned, is that this just has to deal with real property?
As opposed to
As opposed to,
Watch yourself. The consumer, it's illegal in the state of Washington to lend money in any amount without being licensed as a consumer loan licensee for a consumer loan, period. Now there's some exemptions. So whether it's a mobile home or real property, I'd say you have the same considerations.
So if I know this is like kind of on a different rabbit trail,
Right?
but if I was to sell a car on seller financing, that's illegal to do?
If
As a,
you probably aren't able to do that. Now, if you were a car dealer and you offered seller financing, there are some exemptions for retail sales. I don't understand them, but you can't offer financing.
I'm not sure about that myself. I would have never looked at that, Chris. I would have to go look at that. I would have to think that, most everybody's finances cars and the like.
Okay.
So if you did the business or LLC to LLC and one or more principals of the purchasing LLC occupied the property, would that be blown out of the water?
Go ahead, Rob. Well, I'll tell you what. I'll tell you about a case I read once that scared the hell out of me. The Monetary Control Act of 1982 allowed creditors it preempted state usury law. So a creditor could make loans at greater than 12% in Washington state. Well, there was a case in some state with a usury law. This group was putting together financing in the name of a creditor. There was an immediate simultaneous assignment to one of the investors. The courts ruled that they were circumventing the law and ruled the loan usurious. So I caution anybody to circumvent the law. I don't know what the point I'm trying to make, but I just wouldn't trust that. I don't know that a smart attorney couldn't say, look, this is Tyler's in the LLC. He and Joe are roommates. They own the LLC. They live in the home. This is a residential mortgage loan transaction, especially if you created the lousy LLC to make the loan.
Or created the LLC to purchase
Or to purchase, that's what I meant.
the property?
Yeah, that's what I meant.
Yeah. Which, I guess you can make the argument, well, we wanted to do it for, other reasons. Anyway, okay.
Yeah.
That's what a jury of 12 people whose only requirement is they have a driver's license to decide 2 years later.
Yeah, and
A couple $100,000 later.
and they decide they really like the gal who comes in that's the victim, and they don't like that pencil neck Stan Brazington and his dad, So go ahead.
I'm unclear if the state seller financing the property, what happens to the buyer and all their money they paid, and how do they get a new, do they just go get a regular loan?
Well, my opinion is that the state isn't going to come in and fine these sellers and say, you shouldn't have offered this financing to this purchaser. This deal's, we're rescinding this deal. The state's not going to do that. When it's going to rear its ugly head is when the seller isn't getting paid, the seller tries to foreclose, and the borrower goes to their attorney, and their attorney says, you'll never have to pay this loan back. You're going to own this home free and clear someday because they violated the Consumer Loan Act. And even if we don't get your home free and clear, it's going to take 3 or 4 years to litigate this. Just kick back and enjoy rent free, and I'll handle everything. And when we're done, you'll probably get a little judgment, and I'll get my attorney's fees, and then you can move. That's a pretty good deal. Somebody's getting foreclosed on, and now they get to live in their home free for 2 or 3 years. So.
Yeah, DFI is not the NSA. They're not everywhere. They're not listening to everything. All right.
Yeah.
So, I mean, they don't have the resources. There's like one individual in Olympia is about all that handles this stuff. So, like I said, it's only that stuff that's going to come up is when it goes into default somewhere down the line. So that's what you have to look at, is you want to make sure that if you're going to go to the time and effort and do seller financing, and you're going to rely on that income source, that you make that asset bulletproof. That's all.
Yeah.
Is this all an outcropping, from the consumer protection aspect of what happened over the whole real estate foreclosure debacle, the whole thing with banks? Is this why this is happening?
Yes.
They think that we're taking advantage of Joe Consumer?
They threw the baby out with the bathwater when they went in to change the rules on mortgage lending and mortgage origination. They threw the baby out with the bathwater. They didn't intend. I don't think they intended to tube seller financing, and I think in the long run they're going to make some changes so that seller financing is a little more user friendly.
Yeah. At least for now, I mean, when you have such historically low interest rates, people can do conventional bank financing, but as the Fed interest rate starts to climb back up again, what you're going to see is more and more of the seller financing. Because if you look at historically where was seller financing, is back when it had interest rates that were at 12 and 15 and 18%. So that's where you start to see it. So right now, seller financing is always kind of at a lull. If you talk to, I've talked to Dave Berkey at Adept Escrow. Does anybody know Dave? He's one of the owners of it. I was talking the other day about, because they're a contract holder. So if you did seller financing, they would be at one of the companies here locally that would actually hold it and keep the node and keep it, the numbers. And I was asking about this. He says, we are really at the historic lows right now, but we are starting to see an uptick in seller financing a little bit more than in the past years. As the real estate market starts to recover, people actually have equity that they can sell. I mean, for the longest time, people had no equity to sell. Now, with the real estate coming back, you're going to start to see that. So more contracts. So also, if you are in a note buying, I mean, note buying was historically a very traditional way in real estate, and that's how the Sandifer family made their initial fortune in Metropolitan Mortgage, was in note buying. Mm-hmm. If you do note buying, you have to be aware of this stuff, because you got to make sure that note you buy is not going to have issues with it.
I got a question for you. Oh, go ahead.
So, the service loan service, I am going to go ahead and do seller financing on the owner of my property. And I go to Adept and I say, hey, would you service this? Is there liability on the Adept side if they do it?
No, they're not. They're just a servicer. But you could put lease options, for example, lease option into escrow. People do that all the time.
Well, that was number one. The number one concern was must be a natural person. So going on to number two, the seller must have not have financed another sale within the past 12 months. So my dad's closing his sale this week. He can't close another sale until December of 2014 with seller financing.
You just blew my deal.
No, I didn't. No, I didn't.
I've got another one pending.
I know, don't worry about it. Don't worry about it. This is just Annie's opinion, and I think she's wrong. We'll get to that in a minute.
Derek said he thought I could do it.
Yeah, I think she can too. But let's see what Annie Fitzsimmons, the attorney that drafted this, what her 5 considerations are. Number 3, the seller may not have constructed or acted as a contractor for the construction of a residence on the property in the ordinary course of the seller's business. So a contractor can't build a home and sell it seller financed. Number 4, the repayment schedule may not result in negative amortization. Number 5, the financing must have a fixed rate of interest or an adjustable rate of interest that is adjustable after 5 or more years, subject to reasonable annual and lifetime limitations on the interest rate increases. And that's it. So those 5 things. The seller must satisfy all 5 tests to provide seller financing. Any questions on those?
Are there any, like the state level, there's waivers, are there any federal waivers?
I don't know. Yeah.
Chris has all his properties in trust. I would imagine he has a lot of separate trusts. Therefore, is he restricted to one trust per one sale or one transaction per year, or does he do all of them at the same time? Got 29 properties, do them all the same. They're all owned by different trusts.
What do you think, Rob? You're the attorney.
I have 10 different properties, 10 different trusts, which by definition is 10 different people, right? And that's what you're saying, right?
Yeah.
Yeah, oh, 29. So 29, 10. So 29 different people, 10 different people. Is that 10 different transactions, basically? I mean, 10 different.
Would that could you make that float, in other words?
Yeah.
Seller. If you actually had separate beneficiaries on each trust, you'd probably be okay. But the problem is that you could say, okay, well, I have 30 different LLCs, but if it's all the same owners of all of them, then realistically it's all still one owner. You might have different legal owners. The same would go with the trust. At the end of the day, if it's you and your lovely bride as the owners of those, or the beneficiaries of those trusts, and somebody's really aggressive and they wanted to go after you for it, that would be their argument. Again, these are all nice theoretical points, but at the end of the day, what ends up happening is you get to spend several $100,000s going up to the Court of Appeals to try those issues. So, to answer your question, I don't know. If you want to spend a couple $100,000 like Stan here, he'll be able to educate you on that one.
One more possibly esoteric question.
Right.
Does I protect you to have it in an ERISA envelope?
What?
Does it help you to have it in a solo 401k, which has ERISA laws, rather than a Department of Labor laws, which is a Roth IRA?
Again, I
I
don't
don't
know
know.
answer that question. Again, that would be one of those things you get to take up to a Court of Appeals somewhere to answer that question.
Okay.
Right.
I had a comment on this. I added this. I knew my dad was going to be here, and I knew he'd go, "Holy shit! You just queered my deal." So Stan's comments. It occurs Annie did not explore the federal rules for sellers to finance up to 3 sales per year. See the DeMarco Law Firm Professional Service Memo. Welcome to the bank, Mr. Seller, dated April 2013. So let's get that out. Take a look at it. If I can find it. There's 30 of these is also.
So while we're passing these out, just a little bit on the trust.
Can you guys share? Or? I won't ask you guys to share. You don't look that chummy.
We're pretty close now.
This guy was bringing up is that if I have 29 different trusts, it makes it
Are you two together?
more difficult to find or to be able to put all 29 properties linked to me directly. So if if Stacy is, if I'm seller financing to Stacy and something happens with that trust,
Okay, great.
she's got to go out and find.
Can you share?
All other 29
Yes, we can share.
transactions that it's very difficult to find
Pass that
those
down there.
transactions because it is a trust as opposed to me being tied to the.
There you go.
Publicly there.
Associated with the trust.
Right, because I
Oh.
purchased it in the name of the trust. Did everybody get one of these?
I didn't get one.
Well, what you're referring to here is this concept of what we call practical anonymity versus absolute anonymity.
Yes. Right.
You know, at the end of the day, if you get anybody aggressive enough, they will be able to find.
Yeah,
It
they
just,
can,
it,
right.
it
It
keeps
just
the
makes it
fact,
more expensive.
yeah, it makes it a little bit, it makes it more difficult.
Price tag on money.
Is that where the corporate bail comes in?
Right.
This Demco letter was circulated by a law firm that represented Windermere. It was circulated in April. My Windermere agent was good enough to email it to me in April. But the first part of it from here up is the five things that we just spoke about, and he concludes none of these requirements should present an undue burden for an individual seller who wants to finance the sale of one home. And then he goes on to say up to 3 sales per year. And here's what this particular attorney has to say about the federal concerns and how you can finance up to 3 sales per year. A seller that is a corporation or that finances more than 1 sale per year faces substantially greater requirements. Boy, that's interesting, a corporation. I'm going to assume so he's inferring that somehow a corporation can do this, and I don't know what I don't know about that. A seller can finance up to 3 sales per year, and I'm going to assume that this seller must be a natural person, a state, or a trust. The seller must provide financing to the purchaser of the property that serves as security. That's one of so you can't cross-collateralize it with something else. The seller did not construct or act as a contractor for the construction of the residence. The seller financing is fully amortizing, no balloon payments. The seller determines in good faith that the purchaser can afford the payments. So you got to underwrite the loan applicant. And the financing has a fixed rate for 5 years, and any adjustments are reasonable. So this guy says you can sell up to 3 a year. In any case, get yourself a good attorney if you're going to offer seller financing. And
So, to go back to this point number 2 about acting as a contract. So if I pick up a property and I'm doing a flip, obviously, if I'm doing more than $500 in
yeah, but
trades,
you're
technically I am acting as a contractor on that.
But it's not construction.
you're not constructing the residence.
Construction.
We're only talking about new construction?
Yeah,
on
for the
Yeah.
construction.
Yeah.
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 Okay.
I think so.
Did you have a comment? Now let me put readers back on and I'll see what page 2 says. I read it yesterday, but I can't remember what it said. Oh, then this goes on to the Washington regulations. This attorney shares some of the details here that in the middle here, these 4 concerns. First off, the rules have changed since he wrote this letter. You know, they're giving that specific exemption if you're selling your owner-occupied home. That's exempt. You don't have to go to DFI. And when he wrote this letter, that didn't apply. When he wrote this letter in April, he stated DFI does not recognize any automatic exemptions to the Consumer Loan Act. Instead, sellers apply to DFA for an exemption based on the seller's circumstances. Sellers should be aware that even if they receive an exemption, they still are subject to a number of requirements. And these are really important. 1, sellers who do not provide a good faith estimate must give the buyer a disclosure summary form, and I'm going to pass that out in a few minutes. The seller must hold the note to maturity and cannot sell it. The seller must foreclose in accordance with applicable laws. And the state's real concerned about the usury limit of 12%. So that covers the DeMarco letter pretty well. Rob emailed me that. I thank you, Rob. Rob also emailed me this interpretive statement. I'm going to pass it out. It doesn't really share anything new. Whoops, I meant to get it out to him. Can you pass that around? But the interpretive letter is a couple years old now, and it's written by Cindy Fazio at DFI. And it's very good. It's very, if you read it, it'll help you understand what DFI's concerns are. And the final thing I want to hand out is this Form 22C, which is a financing addendum to purchase and sale agreements. Let me keep one of those because I want to talk about that just a little. Building looks good, Tyler. Been watching it, I stopped by here one time when had it all tore apart and you weren't here. Yeah.
Did he get a contract? Did he carry a contract on this?
Yeah, but it's a business deal.
Do you have a waiver on it? Oh. Hey, let's talk.
Yeah. Yeah.
Oh, we'll find some reason.
This form's really excellent.
That's right.
So if you're going to have real estate financed by the seller, just go through the form. You'll see the limited use or the 5 things that we just talked about that the state's concerned with. Number 2 concern that whoever wrote this is attorney review. They make sure an attorney gets involved in your seller finance deal. That way, if you get sued later, maybe you can sue him.
Yeah, suing lawyers.
Yeah.
I'm a landlord.
Limited practice board forms. We'll get to those later. Blah, blah, blah. Waiver required. Seller acknowledges that seller is required to obtain a waiver from the Washington State Department of Financial Institutions. So this form was drafted before they put that specific waiver for the owner-occupied residence. There's an exemption for that. So they'll update this. Then it talks about the down payment. Blah blah blah. Terms and conditions of the note, the deed of trust, what forms we're going to use, assumed obligation and method of payment. Whoops. Where did that disclosure? It was on the yellow form?
Yeah.
The
green one.
The green one. Okay, can we go back to the green one? This is probably, as a mortgage guy that really discloses the terms and conditions of his loans very clearly to his applicants, this is probably the worst disclosure form I've ever seen. It doesn't tell you what your total closing costs are. It doesn't tell you so many things simply, but it's what the state came up with. If you're going to provide seller financing, you have to disclose. You have to use this disclosure form to disclose the terms and conditions of your seller financing. And it's pretty simple. 2 pages long. Well, that's all I had to share. Anybody have questions of Rob or I?
Let me just ask you 2 questions. How many know the difference between a selling on a note and deed of trust versus a real estate contract? All right. Here's it. If you had, let me ask you this: how many in this room would, if you're going to sell a piece of real estate, would want to do it on a note and deed of trust? How many hands? All right, I got 2 hands. And how many would like to sell on a real estate? All right. I personally like real estate contract for this reason, is that if you did have to ever foreclose on it, it is significantly much faster. I'll give you, for example, with a real estate contract, you can have it to sale or getting the property back in approximately 90 days versus about 6 months on a note and deed of trust. If there's lots of equity in the property, you like the real estate contract because there is no public sale on a Friday morning for a real estate contract forfeiture. What ends up happening at the time, if the 90-day period lapses and they don't cure, you can then immediately record a forfeiture of that contract. The seller now becomes the owner, and all of that equity now goes back to the seller, versus if there's lots of equity and it's on the courthouse steps, then what ends up happening, you get a feeding frenzy. And you as the seller, remember, you just get what the balance of your note is. That's what you bid in, is what you are owed. And then if you want to bid more, that means you kind of come out of pocket, so you don't get all of that equity. So that's another reason. 3 is cheaper.
And that difference that you pay goes to the seller, right?
Well, it's interpleaded to the court.
Yeah, I mean, if it's bid over, if it's bid over the amount.
If I'm a junior lien holder, I'm going to argue that money's mine.
Right.
Yeah, right.
Right. There's a pecking order by statute as to who gets that.
I mean, assuming there's only one deed of trust on it.
Right.
Yeah. Right.
So you would have to pay, so you're foreclosing on the seller, has a lot of equity, but you'd actually have to pay the seller in excess of whatever the note is if you actually want the property. In essence,
Yeah.
basically.
Yeah.
It goes in the court, he has to claim it and all that.
Right.
But, so,
Yeah,
as
and
opposed to the forfeiture, you just file it, boom, you're done, property's yours, and you get all the equity.
They can file bankruptcy to stay the foreclosure, though,
Well,
can't they?
that's like any.
Yeah.
Yeah. And I do those lift stays fairly often.
I've got a question for you. How many people have done a foreclosure in the last year? The process to foreclose a deed of trust has changed a lot. And before you can serve a notice of default, you have to document that you've called the applicant 3 times. And you can't just do it every morning at 8 a.m. You have to call them different times of the day. Then you have to send them 2 notices. And the notice is about 3 or 4 pages long. The notice tells them that they have the rights and that they might want to call a consumer credit counselor or an attorney. And it lists consumer credit counselors. It tells them that they have the right to mediation. And inevitably, before you ever get to file your notice of default, the borrower calls a credit counselor. And let's say this is in November. And credit counselor says, oh, shoot, request mediation. So they request mediation. Mediator's appointed. Send him a check for about $175, $200 a piece. He sets an appointment in May to mediate. So you go to the mediation. The lender has to mediate in good faith. So what's that mean? Well, you pull up the FDIC's Loan Modification Program Guide. It's 28 pages long. I've read it like 4 times. And you work through what it entails to mediate in good faith. And the lender has a duty to mediate in good faith. And you have to offer them to amend the terms and conditions of your promissory note and structure it so they have a debt ratio not exceeding 38%. And if you have to lower your interest rate, you have to lower your interest rate. Now, who would like to do that versus a real estate contract?
Well, no, you're slightly right there.
Okay. Well,
I don't know if some of you know this, I actually represent Northwest Trustee, and I am the face, I do the mediations for the lenders.
If you go to mediation, you will be Rob on the other side of the table.
I will be for the bank, yes.
Yeah. Okay. Okay. Well, good.
And so what he's referring to, there was an amendment 2 years ago the legislature passed. And interestingly, if you look at the legislative history, it passed 95-0. So even your most conservative Spokane Valley legislators voted for this. So this wasn't some pushed from the Puget Sound type of act. So it passed almost unanimously. And what it requires is essentially that the big banks, all right,
Right.
your Spokane teachers, your Numericas of the world, they are exempt. Washington Trust exempt.
Really?
But don't they have to
Small
apply
banks,
for it?
small banks are exempt.
Don't they have to apply for the exemption though? To
No,
be
they're
exempt?
just exempt by definition. Of course, you know, it didn't help that their lobbyists were in Olympia at the time when, you know, they kind of set the bar big enough that. All right, so what ends up happening, also seller financing is exempt too. There's no requirement to mediate on those type of transactions.
Okay.
So what ends up happening?
Boy, we need a different attorney, Dad.
Right. So what ends up happening is if you're on let's say you're behind on your home loan to Wells Fargo and it's a Fannie Mae loan or a FHA or USDA, whatever it is, and you get behind on that, what ends up happening is the lender, before they can start a foreclosure, there's an intricate process. And at the end of the day, you have a chance to sit down with your lender and try to work something out. And to be honest, it's no different than what commercial lenders do all day long when they rewrite notes. You know, you get behind on your commercial loan.
Sure.
The lenders do it all the time. You don't think twice about it. So same goes with homeowners. And it's all driven by the federal government. 99.9% of it is their equations, their formulas. So if you are a homeowner and you're getting behind on a loan and you ever get one of those letters that say you have a right to mediation, there's very specific time frames. You got to jump all over that sucker fast.
20 days.
Right, and then also, if you want to do it, there are some top flight HUD counselors over at SNAP that do this work. It won't cost you anything, or it's very minimal cost. The lawyers who do this kind of work, they're good. They're not as good as the HUD counselor because this is what they do for a living. And so they'll actually be able to get you into some pretty good loans. I mean, you can sometimes get a loan drop down to 2%. I've seen people that are behind 2, 3, 4 years still get to keep their homes. So what you're saying right there is, and it doesn't matter if it's a note or deed of trust because big banks don't do real estate contracts.
Right.
But
I'd like to suggest to somebody, and we've done this several times, is if you have somebody that can't pay and it's obvious they can't pay, is go sit down with them and say, it's going to cost me $3,000 in attorney fees and 6 months to get you out of here. If you'll sign off on your place, I'll give you $3,000. And every once in a while, it'll happen. And it'll save you a lot of time. It can save you more than a year. And maybe they'll come back and say, I want $3,500. Probably, depending on the situation, to do that.
Yeah.
But,
that's what's called a deed in lieu. In other words, it's a deed given by the owner in lieu of a foreclosure.
down, I paid $50,000 on a big piece of property to avoid the long foreclosure.
Yeah.
The forfeiture, for example, the costs are going to be typically less than $1,000. You know, if you do a foreclosure, for example, through Northwest Trustee, for example, typically there's $1,000 fee, and then your all your costs, which are going to push you up around $2,500. Publication, you know, publish it in a newspaper. That's the only thing that keeps these newspapers in these small communities alive, are the legal publications. Yeah. So they just keep jacking the prices up on that. Yeah. So, like I said, you're almost always better off going real estate contract whenever possible.
Okay, so scenario is home sold to realtor via financing that was a little bit closer to hard money than conventional.
Nobody in this room would.
Yeah. Realtor requested a second. Second was provided. Realtor is somewhat familiar with the law. Lender was not familiar with the law. And 6 months behind, no property taxes, no Vista bill, paid, I mean, it's time to do the notice of default. What is a resource in addition to you where someone can review the actions prior to this time taken to be sure they're consistent? Lender had a visit with the person in person, can go through phone logs and document times and dates where the person was called. But, you know, according to what Stan was saying, but this mediation and notifying of rights.
Well, that's only if you're Wells Fargo. That's, I mean, it only deals with the big bank foreclosure.
So,
Okay, so that's who has to do that. It's not.
No.
Okay, I had that totally.
No,
See, that's-
the Washington Trusts of the world, the INBs of the world are exempt
see now,
by
And it
definition.
has to be owner occupied too.
And it's owner occupied also. If this is a rental property, you don't get to have these rules. Now, having said that, there are some non-owner occupied government programs out there. There's one called HARP, H-A-R-P 1 and 2, that theoretically have the ability to help you modify your rental loans, but don't hold your breath on those.
see, Vic,
Theoretically, it's a proper use
So
of.
you could proceed with a regular foreclosure as a small,
Absolutely.
like one, yeah, you could
I
do
would-
that without any of the same.
I would hire Rob to do it. Gene and I have been using another law firm, and they told us that we had to offer this mediation. We've been offering mediation on these deals for the past year, and I've been involved in 4 of them.
No, you can stay away from those, yeah.
Yeah, and you know what? The mediation actually has worked out fairly well. You know, we had one. Maxine is part owner in it, where we mediated and we lowered the rate. And at the mediation, they agreed to pay us $10,000 within the next 30 days. And they made 8 or 10 payments at $5,000 a month. So we got $40,000, you know.
You know,
And now we're foreclosing again.
You know, creditors, it's always in their best interest, almost always, to work that. You know, there's banks don't want property back; they just want cash flow. They don't want to manage property. They don't want REOs. All right, so they, you know, and to be honest, the big banks do get confusing. Trying to work with a Bank of America, for example, can be very frustrating. But again, you know, they're out, but the banks are becoming better. And what your experiences were 2 years ago or 6 months ago, I mean, there's a lot of political pressure on them to modify their practices, so they get better at it, for example.
You want the floor again, Chris?
I suppose, anybody have any questions? That was good stuff. Give these guys a hand.
Go ahead. You want those, Rob? I got.
I'm gonna take this one.
Okay. You want that one? You got that one, huh? Okay.
Turn the heat up, but,
Make sure you turn it back off.
actually,
Let me
you guys
sit over here.
But I think it was such good information, hopefully nobody fell asleep. So, thanks, guys. I appreciate you guys bringing the information for us.
Hi. How you
Is that
doing?
good for you guys? Is that helpful?
Good to see you.
So if you're doing like my business practice, it's really good for me. 'Cause I have a lot of different programs that I offer sellers, and so part of those programs are rent to own, real estate contract, or seller financing. And I have certain rules, which you guys should all have rules that you go by when you're investing. To instead of investing emotionally, you invest by your rules. So I have certain rules that I go by. So if somebody's offering me some money to put down on a property, I just go to my rule and I say, okay, that fits in my lease option rule. If they offer me more, that fits in my real estate contract rule. And if they offer me even more, that fits in my no deed of trust rule that I have. So I can adjust those rules based on this information and risk. That's what it's about. So like 20% down is my rule for a no deed of trust. 10% is my rule for a real estate contract. But in light of this, I might adjust those rules a little bit depending on. Actually, real estate contract is seller financing, so we still have to do the waiver. Okay. So anyway, that was good information, guys. I appreciate you guys bringing that. Does anybody have any other questions regarding seller financing or real estate in general? Joe?
How long does the owner occupant of the seller financing, the actual seller, have to occupy the property to be considered an owner occupant at time of sale?
That's a good question, depends on who you're asking. It's typical at least 1 year. You know, like, but again, it's, general rule of thumb is if you get your mail there, or if you vote there, is typically how you define it. I mean, if it's just a warehouse and there's no bathroom in it, it's large, you define that as a.
I could move in and live there for 3 months and get my, voter registration for 3 months.
So like somebody that was trying to run for city council here relatively recently.
So in my instance, somebody moves in on a rent to own, and they could be there for 5 years and have enough money saved up that I could convert them theoretically to a real estate contract after 5 years. And then 5 years from now, I'll have to go get the exemptions or get the waivers or whatever it is, whatever hoop I got to jump through. But we always talk about when they zig, we zag, right? So it doesn't stop us from doing real estate. You just got to figure out how do you zag. What do you got to do in order to be in compliant? So, anybody got the time?
8:07.
8:07. Awesome. Good timing, guys. So we got about 20 minutes to do the deal forum. Do I have our? We'll do.